It is a bit portmanteau, this talk. It's got at least 3 different sections, all of which could have been separate talks, I thought, but I thought it was fun to put them together. So shall we say, perhaps that, a bit like me, it is broad rather than deep. And then the whole PRISM thing happened, which actually happened rather funnily when I was in Berkeley at a privacy law conference. So there was much plotting in corners of the Europeans there and so forth, and I thought I had to involve what had happened lately into the talk, so it is rather splodged on the beginning. So that's the ad I just explained. I go everywhere, give talks, and completely forget to plug my own institution, so I'm afraid here is the mandatory advert for anyone who might be thinking of a master's or a PhD in law and the internet, internet law, freedom of speech. We cover it all, copyright. Do come and see us. Lots of stuff on the website, okay? And also links there to our various blogs as well. Ad over. So the way in which I decided to link in PRISM is that I think it's often useful to start any discussion of data protection, particularly with an audience that is principally non-lawyers, though I recognize that there is a great deal of expertise in the area here. By asking this question. This is how I start with my postgraduate class. Do people actually still care about privacy? Because we've had a sustained attack on that idea, clearly throughout the last decade, throughout the dot-com years, right? So here on the one side, we have Mr. Zuckerberg, the star of the social network, right? Perhaps the leading poster child for this idea that no one is really interested in privacy anymore. It's not cool. The kids are not interested in privacy. So here he is, fairly recently quoted extensively as saying people have really gotten comfortable not only sharing more information in different kinds, but more openly and with more people. Privacy is no longer a social norm, at which point a reasonable storm of protest broke out, perhaps indicating this wasn't as obvious as he thought it was, you know, perhaps not as obvious as it was in Silicon Valley. On the other hand, cut to 3 years later, 2 weeks ago, you know, when the news hits that apparently, because we have no actual, I think, proof of any of these allegations so far, that apparently the entirety of what we put on Web 2.0, the stuff we put on Gmail, the stuff we put in Google, the stuff we put on Facebook, and a variety of other companies, was being scooped up by the US National Security Agency. And then latterly we found out that it's also being scooped up by the UK's own GCHQ, and possibly, as of yesterday, I think revelations that it may have been other countries involved in this scooping, including possibly Germany. So here's a response, you know, that seems to show that people do care about their privacy, that they're not happy, at least, about state surveillance. I thought this was really laying it where it fell. Washington is using American-style Stasi methods, said Marcus Ferber. This is not someone I'm familiar with. Is he a well-known name? Okay, he's obviously someone who thought he could just say it like he felt it, right? He said, I thought this era had ended when the DDR fell. So, did that take me? Oh yes, that's just for the joke. There's been an absolute outpouring of creativity around the events of the recent weeks, and this is just one of the ones that made me laugh on the train, so I stuck it in. Do you want to share this with public, friends in the NSA, only me in the NSA, only the NSA? The new Facebook privacy settings. So yeah, this was put in before the revelations I saw yesterday in The Independent. In fact, visual aid. Where's it gone? All right, I'll find it. I thought I brought it. Yeah, it was interesting that, again, perhaps this illustrates the different conceptions of privacy in different countries. I mean, one of the things that the digital rights people in the UK, who I'm associated with, have been dismayed at is PRISM fatigue. You know, that 2 weeks on, it's only really in the headlines in The Guardian, who have a vested interest in breaking it as they broke the story, and they're also very associated with WikiLeaks and Assange and so forth. But in the rest of the press in the UK, very much it has disappeared beneath the waves into being concerned about something else. Meanwhile, here, it seems people care rather more about it than they do in Britain, and I said on Twitter, it's nice to see the Germans are defending the British right to privacy because we don't seem to be able to do it ourselves. So here's your justice minister writing to ask, what's going on? What is...
Quite clearly they wouldn't answer that letter.
I think so. Indeed, I don't think they've actually released the text of the letter, at least not as of when I was finishing this talk off 3 days ago. I could not find the full text of the letter. I think the general policy is they won't say anything about national security, they won't confirm, they won't deny, and that just... But it was kind of an interesting event, I think, and I understand that it has been very prevalent in the press over here. Yeah? So that's really just an introduction. As I say, I didn't have time to do a proper talk on PRISM. It would be a very good thing to do another time, but I think it illustrates the sheer visceral horror, actually, that people do still feel in their hearts when they discover that potentially the most intimate parts of their life are being revealed and systematically disclosed and then mined and profiled into information about them. I think there is still a very knee-jerk feeling that this is bad, this is wrong, this is an invasion. And I don't think that is new. Despite good old Mark Zuckerberg, who's on this slide too. Now, this is an older slide, right? This is from when I actually gave a major talk on this in 2010. And even then, I think you could see that worries were rising to the fore after the kind of euphoria of the original dot-com bubble. So, for example, I was amazed, that was in kind of mid-2010, when the news, after a sustained period of controversy, that Facebook had changed its privacy settings so as not to be quite so invasive, briefly, was the lead story on Channel 4 News in the UK. You know, that's a minority program, but still, for a story about settings, you know, settings on our website to be a lead story was amazing to me then. Now this happens quite a lot, but I think that was the first time I had seen it. And then, of course, again, some of you may be aware, this is a particularly personal British grief. We've had the experience over the last, 2-3 years, of discovering that the voicemail of very many people was being hacked by journalists working for the Murdoch empire, notably the News of the World. And particularly when the news broke that this murder victim, Millie Dowler, that her voicemail had been hacked after her death by journalists trying to find out things, which had incidentally given her family hope to believe she was still alive and accessing her emails. That news horrified people so much that then there was a sustained boycott on the paper and by its readers and by its advertisers, more to the point, which led essentially to them closing that paper, which was the best-selling paper in the UK, right, which is a point that really should be overstated. Yeah, and one of the best-selling papers in the world, and they closed it. Now, there's a lot of politics behind that, but still, I think these two both stand as examples that people do care about privacy. Okay, and that's my starting line, is this is not something we can just hand wave away and go, we're all for innovation, we're all for entertainment, we're all for social media. I love social media, but I want to see a world in which I can engage with the digital world online and the digital lifestyle and still have some kind of control over dissemination of my personal data, okay? So that's my stated kind of normative bottom line, right? So, again, I'm not going to go through all this. This is just meant to be introduction, really. Just to say that I think, you know, there has been systematic evidence collected across Europe that this is not an isolated feeling. This is not just a bunch of crazy tinfoil hat privacy fundamentalists. So before how many people are aware of the draft data protection regulation? Okay, not everybody. Right, I will be explaining this, okay? But in Europe, data protection in the sense of informational privacy is controlled on a fairly, though not totally, harmonized basis across Europe by an instrument called the Data Protection Directive. Okay? Now, the directive passed in '95 and is fundamentally based on principles that were enunciated, as we'll see in a second, in 1981. This is a long time in dog years, you know, this is a long time in internet years. So fundamentally, this instrument has been struggling to deal with the digital world, with the internet, with digitization, with networked information, right? So for the last now, January 2012, for the last year and a half, we have been in this period of pitched controversy and lobbying over reform of the Data Protection Directive in the form of something called the Data Protection Regulation. Okay? So before the draft of the regulation came out, which was in January 2012, as we'll again see in a minute, a lot of prior work was done trying to find out about the attitudes people had towards privacy and control of personal information. And this is, you know, simplistic. Obviously, you can go back and read the entire report, which is pages and pages. But I pulled out here some of the most obvious high points, you know, which is that around 60% of Europeans are giving away their data. They are using the facilities online. They are shopping, buying things, selling things, Amazon, eBay, all the rest of it. They're using social media. They're using Facebook, Twitter, Google. You know, there will be local social networks, obviously, in all your own countries, and so forth. But that's a very high percentage of Europeans, and obviously rising. And it's a very sliding scale between countries with the highest internet uptake, generally in the north, the Nordic countries, UK, Germany, and the Netherlands, and the lowest as it gets warmer, really, and it's nice to go outside. So the lowest you find tend to be things like Cyprus and Malta, maybe Portugal, and some of the accession countries. So, okay, having said that, there is this baseline that people are using the internet to disclose data. Here's some of the figures. They found that people said, this is self-disclosure, so inaccurate, but people said that they disclosed biographical information, almost 90%, social information, almost 50%, and sensitive information, which has a particular meaning in data protection, to mean information about things like your health or your politics or your sexuality or your religion. Very intuitive categories, I think. Almost 10% said they were revealing that kind of information. And I suspect that figure is heavily underestimated, actually, because you can derive a lot about people, say, from photos, about their ethnicity, their race, even their health, yeah? Which people don't tend to think about. And then, you know, the key figures, 70% said they're concerned and feel that they've lost control of their data. That's really what that is saying. And I think, again, that figure could actually be higher, because people tend to overestimate their own control over things. There's an egotistic factor. And 74%, and this is interesting for what we're coming on to, a higher figure, interestingly, said they wanted to give specific consent before their data was collected and processed. So that might mean, for example, and this is purely, you know, my spin on it, this is not from the survey, that might mean that they're not very happy with ticking the box that says, I accept the terms and conditions when, say, they join Facebook. What they'd rather do is give a specific consent, as in, I agree that you can take this information, that say you can take my picture and you can analyze it using face recognition. Or I agree that, you know, you can take my data and use it to send adverts to me. But they'd like to give these more granular consents, okay? Right, so this is what I was talking about, okay? Having explained very, very briefly, I know, that the Data Protection Directive exists, which does regulate this area across the whole of the European Union, right, and is then implemented into each member state's laws. The question was, eventually, after, you know, almost 20 years of backpedaling on this, was how to reform it in a way that might deal better with the digital challenges. Now, I'm not going to go through that list. This list is from my teaching handout. You know, the lawyers in the room can scan down it and go, yeah, 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 yeah. You know? What I'm arguing in this paper, really, and I've discovered very recently that I'm not alone, which is both pleasing and disquieting, and that it means it's not as original as I thought, is that this is fiddling around the edge while privacy burns. These are all making changes that are either about matters that are very important, but to some extent peripheral to the main thrust of data protection, such as addressing the way in which data flows outside of the European Union. That's the PRISM problem, really, right? So obviously it's a big problem, but in some ways it's not central to the philosophy of data protection. Or they're changes that are actually potentially weakening data protection rather than improving it, such as reducing the obligations on data controllers, who are the people who collect the data and process it and control the ways in which it's processed, right? The other people that data is collected from are the data subjects, okay, in data protection parlance. But there is nothing here that really fundamentally changes the basis of data protection. Now, the philosophical basis of data protection that I'm talking about derives, as I already said, from the OECD came out with this list of guidelines back in 1980. Sorry, I think I said 1981. And these describe a paradigm that is summed up sometimes rather colloquially as notice and choice. Okay, so the fundamental idea here, which is based on a kind of individual human rights conception of privacy, is that if someone comes along, like your bank or Facebook or Amazon, and they collect personal data from you, personal data being data that relates to you or identifies you in some way, okay, very colloquially, then you should get notice of why they are trying to collect it. Right, that's the purpose specification part there, right? The three most important for the purpose of this talk, I've actually italicized if you can see that. So the idea is they give you why are they collecting it. You know, the bank should be saying, well, we're collecting it so that we can give you banking services, so that we can verify your identity, so that we can use that data to provide you with billing and accounts, so that we can use it to give you services to transfer payments, right? Then collection limitation, the idea is that once they've told you that, you have the power to say yes or no, okay? Now, you're saying yes to this particular thing, so they only have the right to use the data for those purposes and not for further reuses of their own kind. So again, on a very simplistic level, if the bank gave you that information, those purposes, right, then you would only have, and you say yes, then the bank is entitled to use it to provide you with banking services and not to sell it to marketers, right? Or not to sell it to insurers, right? Because all the information you give your bank may be very useful for other purposes, right? That's the core of what are the accepted fair information principles, right? The FIPPs there. And this idea has become enshrined across a really, really wide range of legal systems, even arguably the US system, right, which is always said really to have no comprehensive privacy system, no omnibus rules of the likes of data protection. And that's why I've started here with the OECD principles rather than just starting with the Data Protection Directive, okay? And the final one I want to emphasize there is collection limitation, because what also goes hand in hand with purpose specification and use limitation is that they should collect, the data controller, the bank say, should collect the minimum possible data to fulfill those purposes, right? That's, again, another crucial part of the story. They shouldn't collect as much data as they can for a rainy day, okay? Which is the bureaucratic tendency. Very well analyzed, I think, in the Colin Bennett and Charles Rabb book on the governance of privacy, the overwhelming tendency of bureaucracies, of civil services, for the best possible motivations, perhaps, to just collect as much data as they can, because it might come in useful, you know? That is the opposite of what data protection says is a valid way to control the leakage of your personal data, because the consequences of those leakages can be very damaging, right? So it's a very simplistic idea, okay? Now, here it is translated into the Data Protection Directive, to come back to Europe. Okay, so again, I'll just mention very quickly, because we've really gone over the conceptual parts, the correlation. So these principles, unlike the OECD guidelines, are law, okay? They're not just advisory. This is law in Europe. Then it gets implemented with detail in each member state. So the UK implements everything to be as business-friendly as possible, the great phrase business-friendly. In other words, they give it the most lax and liberal interpretation possible, whereas Germany, on the whole, interprets it more strictly and interprets it more as a human right and therefore something to be respected and given the fullest meaning, you know? That, again, is a simplification, but you know, anecdotally correct. So here we have the Data Protection Directive, which has a set of principles, and then there are a great deal of detail around them, but these are the key principles, that says that personal data can only be processed, which includes almost everything: collecting it, using it, storing it, data mining it, deleting it, analyzing it, translating it. Everything falls into processing, yeah? So you can only process lawfully and fairly. Now, fairly, as in fact we'll come to see, gets defined here, okay? So I'll come back to that. But fairly essentially often means that you have to give consent, again, just as we said, to a statement of limited, specific, lawful purposes. Right? So that's your purpose limitation again. And then here's your use limitation in the second part of, this is of para 2. Once you've collected for a particular purpose, you shall not further process in a manner incompatible with those purposes. Okay, now there is a lot of argument about what exactly incompatible means, but you can see that there's a generic translation here between purpose specification, use limitation. And also, the collection limitation that I talked about is there in para 3, along with some rules about data quality. Okay? So the data you collect should be relevant to the purpose and not excessive in relation to that purpose. Okay? And there is talk in the proposed changes in the data protection regulation of bringing that in as an explicit new principle, the principle of data minimization, that the data controller should take all steps necessary, including perhaps technological steps like privacy by design, privacy by default, how you set the defaults in a system, to minimize the data that is collected to that absolutely necessary to meet the purpose of collection. Right? Now, none of this sounds really radical, does it? I mean, I always say to my students, it's really not rocket science, you know? It's a best practice guide. Right? It just looks complicated when you get to all the bells and whistles. But having said that, I will now assert, okay, that all of these core principles I've just described, which are often, as I say, described as notice and choice. You get notice of why the data is being collected, and you get a choice whether to agree or not. So notice and consent. That core paradigm, I would say, is about to be shredded to bits and the bits thrown in the bin. And I don't feel that the current data protection regulation proposal, good as it is in places, really addresses these fundamental concerns. Okay, so that's why fiddling around the edges while privacy burns. So here's my, how long have I been going for now? About half an hour, dear Lord, right. Okay. Right. Here are my fundamental challenges. The first one is quite well known. The second and third, I would say, within privacy communities, now becoming apparent but less well known. Within technical communities, already perhaps very well known. So I would argue that we have a decline of any sense of real and informed consent online. So that's the choice part of notice and choice, I would say, is being heavily made illusory and sometimes misleading to the point of actually being actively unhelpful in helping people to control the spread of their personal data. Secondly, also about consent, I'll talk about the impact of ubiquitous computing, sometimes known as ambient intelligence. Okay? Thirdly, the big hype thing of the moment, we were discussing this in the pub last night, well, in the pizza takeaway, whether this actually meant anything real or whether it was just hype word of the day, as brought to you by Victor Meyer-Schönberger in his book, Big Data, which I've just borrowed from Andreas, but I have my own copy. Bought from Amazon at the expense of my personal data. Okay, so big data I will explain, but the idea of data mining enormous data sets to produce inferences or conclusions, to produce new data, okay? In each case, I will argue that fundamental elements of the notice and choice paradigm are being either cut down or actually destroyed. And I don't know what the answers are, is the end on that. I'm useless, really, as a critic, because I can tear anything to pieces, but I have great difficulty seeing the answer after that. So I will put in a few answers that other people have come up with, but I'm pretty skeptical about all of them. Okay, so consent, right? Again, for the non-lawyers. The way that the Data Protection Directive works is that we saw there were those principles, remember? Including the one that said, personal data shall be processed lawfully according to law and fairly. So if you concentrate on the fair, you get to here, right? Article 7, where it says what the grounds for fair processing are. So you have to meet, if you're the data controller, if you're the bank or Facebook or whoever, you have to tick one of these essentially before your processing is legal, right? Now, one thing to say is that these are not arranged hierarchically. People think they are. People think consent's more important than all the rest. Actually, that's not the way the law says it. On the other hand, I would argue that philosophically, I think consent is of greater importance here because it is the one that legitimizes the system, that gives people the idea that they do get to say yes or no, that they get to have control over their data. And I would argue, and this is something I will need to look at more of the historical documents to back it up, that the rest are edge cases where getting consent is either impossible or impractical or very occasionally undesirable, right? So apart from consent, to give an example of one where it's impossible, necessary to protect the data subject's vital interests. So that is when, say, you're unconscious and we need to access your hospital records and you can't consent. So at that point, obviously, you would like the medical people to have the right to get hold of your records, okay? And if you're an adult and you're competent, they can't just ask someone else to give consent for you as if you were a child. So at that point, there is this alternative ground for fair processing, right? That one's easy. The hard one in there, I think, and another one that's obvious is processing is necessary for judicial purposes, public acts, etc. So if a law has been passed, a statute that says, you know, the police have the right to access this data to try and prove that you committed murder, say, then that's a reasonable exception without going into it too much. But necessary for the legitimate interests of the data controller, which is the other one I've bolded at the bottom, is the tough one, in that you can say this is a perfectly viable alternative to getting consent from the data subject. Is that right? Should the legitimate interests of the data controller, that could be a commercial company, trump the right to control of the individual? So it is hedged in the sense that, say, you know, Facebook says we need to take all their information without their consent so that we can supply adverts, and that's our legitimate interest, because our legitimate interest as a company is to make money. Then actually they can't just do that, because there has to be a balance there. This is what the law says with the human rights of the data subject. And your human rights, rather circularly, include the right to privacy or the right to respect for your private life under Article 8 of the European Convention on Human Rights. So you can't just do that. If you're a spammer, for example, you can't just say, well, I'm going to collect all your data without asking you so that I can make money, because that would clearly be contrary to your human rights of privacy and so forth. Okay? But there is a patent tension that remains there, I think, between consent as the guardian, the bulwark of your control of your personal data, and the role of legitimate interest. So that's how things are, okay? Now, even without taking into account the alternative use of grounds like legitimate interest, consent as it's meant to be, which I'm going to contrast with consent in real life, okay? So the definition of what's consent, you know, as a common lawyer, right, from the UK, we go, what? You know, like, this is all very general. Where are the specifics? So there is, for once, actually a specific in the Data Protection Directive, in that there is a definition of consent. And it is any freely given specific and informed indication of his or her, that's the data subject's, wishes, by which the data subject signifies his agreement, okay? And there is an add-on later on that this should also include somewhere the word unambiguous consent. And you just have to look around you at the world. I'm afraid generally using the paradigm example of Facebook, but clearly not just using Facebook, to see that this is not really what consent is like in the real online, okay? So if you talk about online data collection, so that could be in relation to social media, where people give away a great deal of data. It could be in relation to online shopping, where people give a great deal of data away. So that could be your supermarket shopping online, where they acquire all the data about what things you buy every week, every month, right? Could be Amazon, where they acquire data about what kind of books you like, from which they can work out almost entirely accurately your age, your class, your sexuality, very largely. That's where the data mining, the big data comes in. In each of these cases, is consent really freely given to that collection? Freely given in the sense of what's the alternative? Did you get a chance to negotiate? Did you get a chance to say to Amazon, well, you can collect that data, but you're not to turn it into profiles about me, about what I like and what my sexuality is? Can you say to Facebook, well, I don't mind you keeping the data about my posts, but I don't want you to keep my pictures? Not really. Okay, now, I mean, there's a little bit of vagueness around the edges there because sometimes on sites now you can fiddle with the defaults in various ways. But fundamentally, in all of these online scenarios, they are what we call standard form adhesion contracts. You get presented with a set of terms and conditions, which is sometimes called, you know, a use policy or an acceptable use policy or a privacy policy. They're all essentially terms and conditions of a contract. And you don't get any opportunity really to negotiate. You just say yes or no. Take it or leave it, okay? And classically, in the case of Facebook, if you leave it, where does that leave you? Because for very, very many children and young people, not to be on Facebook is social death. And they regard Facebook to a large extent as the whole of the internet, and there's a great deal of evidence on this now. Use it for mailing, use it for sharing pictures, use it for all the purposes which once upon a time people would have used many services for, right? So there's a monopolistic control of power. So freely given, not doing too well. Specific, I've already given the example, you know, would you like to say yes to Facebook? You know, you can use my photos, but no, you can't do this, you can't do that, and you can't keep it for longer than 6 months. No, you can't. You're giving what is largely a very blanket permission for a really wide range of services, right? It's not like saying, I give my data to the car garage so that they can repair my car and give me a bill and keep the data about my address on file, right? That was the kind of specificity that was originally envisaged when they were thinking up the Data Protection Directive. They weren't thinking of huge general purpose institutions like social media and Google and so forth. So what is the Data Protection Directives, the Data Protection Regulation suggesting to do about this situation, to fix it, to give people more control? They're suggesting that for all processing of data, it be required that we use the word explicit. Sorry, that's later, actually. That's just to let you know in advance. Sorry, I don't know this talk too well yet. There is this extra bell and whistle on that for the categories of sensitive personal data, which I mentioned before, which include things like your health data, your politics, your religion, your sexuality. There is supposed to be a ground that you have to give explicit consent. Okay, that doesn't mean written consent, but it does mean explicit. So it could mean, for example, that you actually have to tick a box. Okay, it has to be more than just, we assume you've given consent, tell us if we're wrong. Okay, that would not be explicit consent. Okay, now there has been disquiet tremendously about this for a long time, as expressed in multiple reports from the kind of advisory body on the nuts and bolts of data protection, which is called the Article 29 Working Party. That's that Article 29 WP there. Has produced report after report, really, questioning whether the quality of consent is what was envisaged. But in the meantime, things only really get worse. So this is really the summary in slightly more detail of what I've just been talking about. Why doesn't the consent model work anymore? Well, again, if you take social media and to some extent online shopping and search as well as paradigm examples of giving consent to services online. The privacy policies that I've just been talking about, which are essentially where they're meant to lay out the purposes and the uses and the reuses of the data given, right, so that you can give a meaningful consent, are now completely unreadable, right, especially, obviously, by non-lawyers. They tend to be written at length in legalese to give these companies the maximum flexibility to use the data as a capital asset and to protect the company from any risk or backlash. Right? So, for example, about the time I gave the lecture in 2010, this had hit the press in the New York Times, which was that at that point, the Facebook privacy policy had grown to almost 6,000 words, you know, the length of a medium-sized European academic article. And if you added the privacy frequently asked question page, it was now 45,000 words, so about half of a PhD in the UK, right? About half of a novel. That's a lot of reading in incomprehensible legalese, when what you're really trying to see is the picture of your friend at a party, you know? You're not really going to stop and take that in and make informed, specific consent, are you? So that was one example. And yeah, the US went very hot on the idea that now the Facebook privacy policy was longer than the US Constitution. And I think that was the point at which it hit Channel 4 News. And I think it was slightly shortened after that, but then probably grew again. So if we go back to that one, even if you read it all, would you make an informed, rational choice decision to say yes or no to Facebook? And the answer is no, you wouldn't, because that is not how people operate, okay? So what we find, and again, there's a great deal of behavioral economics research on this, which is fascinating. I don't know if anyone's familiar with the work of people like Alessandro Acquisti at Carnegie Mellon and so forth. It's well worth following up. It's wonderful stuff. What you find is that people have terrible risk assessment. We want jam today. We don't care about risk tomorrow. We want the parties now. We want the fun invitations. We want the pictures of kittens. And we have very bad ability. I too want the pictures of kittens. You know, we are all guilty here. We have very little ability to grasp possibility of abstract risks that may or may not happen to us tomorrow, as opposed to the immediate social gains. And so we go, yes. And it gets worse, right? Because even if, let's just imagine in some perfect world, I was a computer that had made that rational choice assessment of gains against risks at that point, I would have to keep making that assessment. I would have to keep being vigilant, because what they do is they change both the terms and conditions of the contract and the default settings in the settings on the sites all the time. Now, again, this was a wonderful piece of work that someone did round about this same time, round about 2010. What this shows, and you can look at these slides afterwards in more detail if you want, is the amount of data that was disclosed by default if you didn't fiddle with the settings on Facebook in 2005. So you can see actually that it doesn't include that much: name, picture, gender, and some of your friends, really. That's what it's showing. This is how it looked in 2010. Go on. Oops, why is it not doing it? So much for my dramatic reveal. There you go. Right. As you can see, rather a lot more. 2 more audiences as well. That's the other thing it's showing. Like, does it show it to your friends? Does it show it to friends of friends, et cetera, et cetera? That was before you do anything. So again, you would have to have kept checking to see what had happened and then altered your privacy settings accordingly to maintain effectively your informed, free choice as to whether to disclose your data for processing, right? And that's the point at which kind of the backlash set in. So here's what I was going on to talk about. Sorry, what's the consent to, did I actually cover all those? There's even a third bit, actually, sorry, I'll go back to, which just makes things even worse, right? Just when you've got to the point where you've decided that consent simply doesn't work. Is that even, again, if you had read everything, if you'd made an informed decision, if you balanced the risks, if you kept making that balance for years and years, checking everything up, you still wouldn't actually probably choose not to join Facebook if you were a 17-year-old in Italy, because there isn't a competitive market. There's market failure here, again, as the economicists would say. There is not a market of social networks offering more or less privacy, which is how you would see it in a kind of laissez-faire economy. In fact, what you find is that there is a strong lock-in network effect, because people stay on one particular site. They don't leave it when they're unhappy with it, because it's where their friends are. Right? That's the network effect. You can't really go elsewhere, because you can do it and you might get offered better terms, but your 250 other friends won't be there, and that's no good. Okay? So there are some attempts to deal with that with things like the right to data portability, which I haven't got time to go into. But fundamentally, that adds even more so to the problem here of the lack of any kind of real effective consent, because social death not to be on Facebook. For example, in the wake of PRISM, I have heard a lot of conversations in which people have gone, I'm going to give up Google. I'm going to use DuckDuckGo. You know, I'm going to search for a mail client. I'm going to use Tor for everything, right? And 2 days later, they go, oh, I can't be bothered with this. Tor is too difficult. No one wants to be seen using DuckDuckGo. It's just not cool. Its back end is actually Bing, and therefore it has all the disadvantages of Bing, and you're still giving your data to Microsoft. So where's the game, right? And on the whole, I think even in the 2 weeks or so since PRISM, almost everyone in Britain that cared has sort of gone through this process and gone, oh, what the F, you know? So it's not good, right? The market failure in respect to privacy. So by now, that's the part that I've researched to death. I hope I've maybe convinced you of the first part of the argument, I hope, that consent is no longer a successful bulwark in the online consumer market, okay? And as I say, what's the solution we have in our brand new spanking first new law on data protection for 20 years regulation? We have the suggestion that they should change the definition from freely given, specific, informed to freely given, specific, informed, and explicit, meaning based either on a statement or on a clear affirmative action. Does this make a blind bit of difference in any of the scenarios I've just described? Anyone think it does? I don't think so. I mean, you know, I guess the devil is going to be in how it's interpreted into law, how it's transposed in the various countries. But I can imagine the UK transposing it exactly like that. And it will make no difference at all, because you do consent explicitly when you join Facebook, when you send an order via Amazon, when you buy your shopping from online Tesco's or whatever, or Asda, or who's the big supermarket in Germany? There is none. That sounds good, actually. Okay, but in each case, you are making an explicit statement of consent. You are ticking the box, you know, or you're saying, I accept. So as far as I'm concerned, that makes no difference at all, right? And there's some other little changes that are going on, but I don't think that they're anything more than tinkering around the edges. So here's a point, okay, the bit after the but, the things that aren't done in the data protection regulation. There's still no change in what I've seen described as kind of data verification rather than data protection, okay? All current data protection law does is it says, did you get shown what you were consenting to, and did you consent, right? That's notice and choice, if you like, except as we've seen, you have no viable choice. It's not in any way restricting what you can consent to. Okay, now that is what I sometimes call, some people are calling the regulated contract model, which was actually floated when I was on the impact assessment for the DP reg and then disappeared. And I'd quite like to track that one as well. So, I mean, the comparison is to something like an employment contract, right? Even in Britain, people don't put ridiculous terms into employment contracts because it is known that they will not stand up when it gets to some kind of employment tribunal. So, for example, you cannot say that people shall work for 18 hours a day with no toilet breaks. You cannot say that people who get pregnant will be sacked. You know, you cannot say that part-time workers shall have no rights. Okay, as I say, we owe this all to the European Union, and can I say I'm very grateful as a British person. But that's a regulated contract. It's a heavily regulated contract, and there are other examples. We could have such regulated contracts for the data collection industries, which is effectively what social media is. They are not selling you social network. They are selling your personal data. That is their business model. The business model is the narrative of the business. I've learned this recently. It is what tells you the story of what the business actually does. So that's one alternative. Also, just to bring back the legitimate business purposes, there's no restrictions on the use of that as an alternative to consent. There's no suggestion that you shouldn't use that as your first port of call, you know, in circumstances where arguably people wouldn't have given consent, right? So there's no restrictions on that. And what we're seeing coming through the data protection discussions right now during the regulation process is an increasing demand to rely more heavily on legitimate business purposes. And this will become very relevant when, if I get to big data, okay? So conclusion, not much help. I was originally going to score these, but then I gave up on that, but I gave it about 2 out of 5. Right, change of tack, okay? Up till now, telling people stuff that some of you in the room will have heard 1,000,000 times, all right? This is slightly less overdone. Ubiquitous computing. Who knows about ubiquitous computing? Because we have some techies. Yes, well, indeed, I have a slide on that. But the phrase, not everyone's always heard of. So would it be very unofficial if I were to take this off? Okay, so starting from baby steps, all right? Ubiquitous computing is really, you know, the idea that the data collection I've talked about so far really occurs online. Yeah, you put data via your PC or your laptop or whatever, or your tablet or your mobile, into a service like Facebook or Amazon or Tesco's or Asda or eBay or whoever, or DuckDuckGo, right? And the data is collected, okay? So in a way, the damage is limited to what you do online. But we are now emerging into the world in which data will be collected in your interactions with real things, okay? So for example, I have seen blueprints, I mean, these are in real life, for smart chairs. The smart chair would have sensors in it, right? And it would work out how long I had sat in this chair, okay? And possibly what pressure I had exerted in it with my big fat bottom, right? And from that, it might work out various things. If I was a sessile Alzheimer's patient, it might work out, you know, the degree of the severity of my problems, perhaps from the amount of time I'd spent sitting and not getting up and doing anything. If I was someone with back problems, as indeed I am, it might record the fact that I sit too much and I don't take enough breaks, right? So that's an example that's actually happening, okay, mostly in the kind of health scenario. But increasingly, the entire world is being built like that. And that's what we mean by ubiquitous computing, the Internet of Things, ambient intelligence, okay, which I'll get to. So this really started in the consumer market to be noticed with the advent of RFID cards, which are radio frequency ID cards. They have a tiny little chip in it, tiny, tiny, cheap, 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 that does nothing really except say to a suitable reader that has to be very near, I am here, I am here, I am here, really, you know? So here's a biometric passport, for example. It just means at a distance it can be read so that the data embedded in it can be read really easily, okay, if you wave it at one of those things in Heathrow. Oyster, that's a useful one. Okay, has anyone here used an Oyster card as they traveled through London, perhaps? I mean, I have one. Okay, so this is just a smart transport card. Okay, there may well be equivalents you're more familiar with. I don't know, for Frankfurt, Berlin, Hamburg, I don't know. So stored value, it's a little card. I can put 20 quid on it, and then I can use it just by slamming it down to travel in London. And this is tremendously handy. And also, in London, there's a huge incentive to do it because you get half-price travel using it. Now, you could argue, and here's a good conspiracy theory, that that's meant to be a perk to local Londoners. But in fact, everyone I know who goes through London has an Oyster card. So that's not local Londoners. So why do they do that? The best way to use an Oyster card is to register it with your name, with your personal data. Because that way, if you lose it, you get the money back. And also, you can get it returned and things like that. Every time I travel through London, Oyster makes a record of where I traveled, when I traveled. If I lived in London, that would build up to an extensive map of my movements, and even conceivably my movements with whom. And you can tell a lot about people from the fact that they go to this place every Tuesday that isn't their place of work, that isn't where their girlfriend lives, whatever. Yeah? And interestingly, who do you think is making the most use of that data? That's where I see if anyone's awake in the class. The London Metropolitan Police. Because the figures for acquiring that data from Transport for London have gone like that. I had a slide on that, but I left it out. So it shows you the value of that kind of data, movement data, which can now be collected. So this isn't just data about what you do online, it's data about what you do in real life. And it's the best example I know of that. Okay, now we are well past RFID now. So the one that Andreas just mentioned, location data. The most obvious example is we all carry around. This time I will find my visual aid if it kills me. You can't find anything in here. Right, there's my tablet. You can see how many surveillance devices I am carrying on me. And here is my smartphone, which is not an iPhone for various reasons. So everyone is carrying around a cell phone pretty much. The number of cell phones in the world now exceeds the number of people in the world. You know, and that's taking into account all the people in some countries like sub-Saharan Africa or whatever who actually don't have some cell phones already. Because a large number of people have more than one. And a lot of these cell phones are smartphones. So the location tracking is not just at the level of the cell, which is often like a mile wide, but at the level of, you know, yards, which is what GPS does. Okay? So what is this doing? It's essentially a bug that is recording your interaction with the real world in the sense of your location wherever you go. Okay? And here, you know, overstating as usual, but always good for a laugh, is Richard Stallman, the father of open source, saying, it's Stalin's dream. Cell phones are tools of Big Brother. I'm not going to carry a tracking device that records where I go all the time. And I'm not going to carry a surveillance device that can be turned on to eavesdrop. And just to show that Richard Stallman isn't always a complete paranoid loony, one discovers that in the latest download of the Facebook app for smartphones, there is a term and condition that it can record your conversations, the calls you make on the phone. I have not seen this personally because I have not downloaded the upgrade, but I am reliably told it by people. So this is really happening, kids, right? So there's an aspect of ambient data collection in the real world. And here's kind of the end game, okay? Now, this one is dear to my heart because I lecture in Glasgow. Glasgow is not a very nice city, really, in many ways. It has severe problems with health, transport, energy, and so forth and so on. And this is probably one of the reasons why it bid to become one of the smart cities of the UK. And what this really means, again, it's buzzword city, but what this really means is that they are going for the ambient data collection in a big way. So, for example, smart meters. Has anyone heard about smart meters over here? Yeah? Because these are happening, right? This has been mandated by the EU, and I think everyone has to have a certain percent, a very high percent of houses smart metered up by, is it 2020? Something like that. It's not too far away, really. So smart meters sense the energy usage in your house, you know, not just in the sense of you used, you know, 300 units last month and here's your bill for £244, but in a much, much more granular digitized way. So for example, you can tell things like, is there anyone in the house? Because, you know, the energy usage has gone down. Does the energy usage always go down between 10 a.m. and, you know, 6 p.m.? Well, in that case, that would be a pretty good time to sneak into the house and burgle it or plant surveillance devices. But it is somewhat more subtle than that, in that I have seen the range of questions that can be answered using smart meter data. And a lot of them are much more highly sensitive than you would think. So for example, supposing somebody has a room on the ground floor of that little house, and they are also claiming benefit on the grounds that they are not mobile and they can't climb the stairs. And the smart meter data is obtained that shows that when that person was the only person in the house, energy was turned on in upstairs rooms. That's the kind of information that a welfare agency would be very keen on. Or similarly, perhaps a health insurance company, right? And there are a lot more questions like that. So actually, when you start to look at it, smart meter data tells you enormously personal and sensitive stuff. Other ones, smart roads, okay? We are heading this way. We're going to have smart roads because we need smart roads for driverless cars, which we're also heading towards, and in fact, which are being trialed in Germany, I believe, right? I mean, what's best known are the Google cars, which they've managed to get legislation passed in both Nevada and California so they can try them out on the highway. Now, this is a good thing because smart roads and smart cars will save lives because we all drive really badly. On the other hand, it will be complete collection of the data about what road you were in at what time, going at what speed, quite likely with whom, because much of that data might be collected by face recognition via cameras. Okay, the technology is already there and in place in numerous cities, including London, to take photos of your number plate and link that up to car registries so that you can tell who is the registered owner of the car, if not necessarily the registered driver. You can then connect that to face recognition and cameras to work out the two, right? And then you have complete surveillance. And then you could add to it the driverless car scenario, right? Now, what is most obvious about most of these situations, and CCTV is another one that we already have, right, is that there is no choice here, is there? In your ambient intelligence smart city scenario, essentially that choice is taken away from you, and the default is that data collection is on. Because that's how they're useful. You could say, if you were a privacy advocate, that the default should be off, and then none of that data would be collected. You know, and the argument is that smart meters are what we need for environment and conservation of energy, that smart roads are what we need to save deaths on the road and catch criminals and run congestion schemes, that CCTV is what we need to deter crime, you know, that footfall in malls needs to be recorded so that we can maximize commerce and industry and, you know, in the dying shops of the high street. These are all big social utility questions, right? I'll come back to that one. Well, I won't actually because there isn't time. But just, yeah, to say that the ultimate end of this is ambient data collection from your own actual body. So, and this is beginning too. So you get lunatics who have chips implanted in their body. That was a really early story from 2004 about that. But here's a real one, if you like, not a joke, which is information from implants that have been placed there medically. And that's already happening with pacemakers. Smart pacemakers share data with surgeons so that you get continuing information on the state of the heart and the state of the pacemaker. And there was a big scandal at the time that I nicked that picture when it was discovered that that data was being supplied in an unencrypted stream, which really meant that anyone could intercept that information and possibly, though that was the bit we didn't really know, make some sense of it. And if anyone watched Homeland, you'll have seen the scene where, in fact, that story was picked up, I think, and they hacked in and used it to kill the vice president by turning off his pacemaker. And though that was probably science fiction from what I was told, it wasn't too far off. So, okay, let me say what I think people thought about the Internet of Things and RFID at round about the time that they legislated for it in the Privacy and Electronic Communications Directive in 2002. They thought that it would be another case of volunteering data. So here's a model of volunteered data, Foursquare, who eventually, I think, now they're still independent, aren't they? They didn't get bought by Facebook. There was Foursquare and there was Facebook Places. This idea that you check in, you know, I'm going to the Starbucks on this street, you know, and there were various incentives to do this, like if you checked in 19 times, you might get free coffee, something like that. And some people just do it because they like it, like collecting stamps. I never actually understand this. In that volunteered data model, obviously, you know, notice and choice arguably still works. At least it works as well as it worked in the previous set of examples, i.e. not at all. But, you know, the principle might still work in the sense that you have a choice not to. And I always turn off anything on my phone or whatever that checks in or tells people where I am. And I always turn off the bit that says yes to Google. And then I turn it back on again when I want maps, like I did this morning. You know, so again, not much choice there if I actually wanted to use mapping technology, which I do because I get lost everywhere. But in reality, the models of future smart cities, ambient intelligence, Internet of Things, are going to be non-volunteered data. It's just going to be ambient data collection with no opportunity for notice and choice. And here's two examples, right? One's a joke and one isn't. So this one on the left was done as a joke, really as a charity campaign showstopper a few years back in the UK. It was an intelligent advert on bus shelters. So it had a little camera. It took a photo of you as you approached. It worked out with, at that point, fairly elementary face recognition, things much better now, what gender you were, just what gender you were, not who you were. And then it flashed up a gender-appropriate advert for this charity. So I think if you were a girl, it gave you a picture of like a sex-trafficked girl, and if you were a boy, it gave you a picture of a starving orphan or something, whatever they thought would most appeal to the gender. And it got them lots of press coverage, which was the general idea. Okay? But that technology exists and will be used. And, you know, sometimes this gets called like Minority Report, when you walk past the billboard and it goes, "Hi, Lilian, we saw that you went to see Iron Man 3. Don't you want to see Man of Steel?" You know? That, again, is current technology, okay? It's just, you know, fears about PR to some extent that are stopping that happening, at least in large cities. Here's one that's really happening. I looked this one up. It was on sale. The price was not that high. This is a face recognition-enabled door. These sort of things are widely used in Japan and China already. Okay, again, you're not getting any choice there about giving away your personal data or having it processed or having your face recognition profile then digitally available to that firm, et cetera, et cetera. Okay, so here's some of the stuff from actually having read actual research. I probably won't go through all this. The essence, how am I doing? Ugh, can I have 10 more minutes? 5. Right, yes, because we want some questions. Okay. Yes, yes. Right, so, okay, I know, I'm sorry. The essence of ubiquitous computing, as I understand it from the reading I've done, and right back to Oyster, who's the guy who more or less invented the idea, is that it works best when it is unobtrusive, when it is invisible, when it is embedded in real life. I sit down in the chair does its stuff. I don't turn it on. I don't say yes to data collection. That's the best way it works. Gonna sneeze. Sorry, hay fever. So this is known as invisible and seamlessly adaptive. Ubiquitous computing also exhibits this feature as it turns into intelligence, into smart cities, of learning from the environment. So without even going on, the driverless cars, the domestic care robots, they learn, they adapt. They learn better, they behave better as they retain data and process it. They don't forget, or else they lose their utility. Okay? So to me, ubiquitous computing is the opposite of notice and consent. Okay? And there is, in fact, oh, there was a quote. Where is it? Anyway, here's another quote from Cass, who I think is a sort of HCI type guy, actually, rather than a lawyer, who says ubiquitous computing will erode all central pillars of current privacy protection. And I think he's right. And there are some suggestions there for solutions, but as I say, I don't have much faith in any of them, but I can come back to them in questions if you like. So very, very briefly, okay, I'll mention my last pillar, if I have not destroyed notice and choice enough already. I have destroyed the notion of consent in the online environment. I would argue that we are very quickly destroying the notion of consent in the offline environment. What does that leave? Well, it leaves purpose specification. You know, if they're going to collect data, at least they damn well have to use it for the purposes for which they said they would. And even if you don't get the opportunity to consent, well, at least you could always go and look up the website of the company and find out what they say they're going to do with the data. That's something, isn't it? Right? So that's our last piece of protection, and that's going. So this is where we get to big data, right? Big data. This book was on the New York Times bestseller list. Again, whoever thought we'd see the day, you know, that a book about data mining was high on the New York Times bestsellers list. So what's big data? Well, it's hype. It's about applying mathematical algorithms to huge amounts of data to infer new knowledge. Now, the new knowledge is not certain, of course. They're just inferences. They're statistical inferences, and so they may not be correct. This is very, very significant when you start to use big data for predicting who might be a terrorist, okay? But that's not where I'm going with this talk. So big data, the key quote, really, these are all from the Maya Schoenberger book, is the third one, that big data is a fishing trip. All the best uses of big data, secondary uses, are ones that people hadn't actually thought of first. Because otherwise, you wouldn't have needed to do the data crunching, right? You'd have thought of it anyway. That's how it works. So where is big data most likely to be useful? In the internet industries that collect huge amounts of personal data, because these have the biggest stocks of data that mankind has ever seen. Okay, and here's some of the figures for the likes of Google, Facebook, and Twitter. And again, a telling quote, there is a treasure hunt underway. Now that's terrific if you're an innovator or a venture capitalist or even someone who's looking for social value, because there are tremendous things being done with big data, but it's completely the opposite of data protection, which is that you process data for the purposes you first thought of. And if you want to reuse it in innovative ways, you should go back to the consumer or the data subject and say, give us a new consent, guys. Right? So is that possible? Again, this is Maya Schoenberger, who has got a gift for putting it simply. How can companies provide notice for a purpose that has yet to exist? How can individuals give informed consent to an unknown? What can you do? Can you go back to every user of Google and say, give us another consent for this use of your data we've just thought of? No, really no. What else can you do? You can ask for a blanket consent to anything. You know, dear Google, here's my data. Please use it for anything you like. There's not much point in that, really, is there? That's not really what data protection is about. We are heading that way, nonetheless, I would argue. And it's very significant that the big fight Google's in right now with the French data protection authorities, I think probably the German authorities, etc., is over combining all its privacy policies, which really means it's saying, you gave me your data for Gmail, but actually now I want to use it with all the other data you gave me for something. right? That is getting very near to saying a blanket consent for big data, and it's clear that's where Google is heading, right? You might say, this doesn't matter, and this is the most common excuse. This doesn't matter because the data results that are produced from personal data are nearly invariably anonymized, right? Because they're statistical inferences. They're aggregate inferences. So you find out that people who buy Saab cars are more likely to respond to adverts for buying holidays in Sweden, you know? It doesn't really matter what the name of the person is. So even from a commercial point of view, there's little value there to some extent in adding names. However, what we've had, again, over the last 2-3 years is a string of articles from computer science and computer security that are now working their way into the legal literature, which say that anonymization is rubbish. That given large enough data sets, which of course is what you have with big data, you can re-identify almost anybody. And again, there's a string of ones showing how easy that is to do. For example, using, if you have any kind of photo image of somebody, to connect that to their image on Facebook and then to derive their real name is extraordinarily easy. It's been done in about a third of cases. So there we go. So there's all kinds of things you could say about big data, but what I want to say is that the more useful it is, again, the less it accords with what might be seen as the purpose limitation and use limitation presets of data protection, okay? And I had better stop there, and I will leave the conclusions there. I failed to give you any solutions, but maybe that's the start, okay?